say stranger to contract cannot sue. So stranger to contract cannot sue means, see, if there is a contract between A and B, there is a contract between A and B, and if there is any problem between A and B, either A can file a case against B or B can file a case against A. This is, but C, who is a stranger, total stranger, he can neither enforce his right of claim against A or B. So who is C? C is a stranger to the contract. So C cannot file a case against A or B. That is what it says. C, a stranger to the contract, cannot sue. But there is one more thing. Stranger to contract cannot sue, but stranger to consideration can sue. Consideration can sue. Stranger to consideration can sue. What does it mean? See, C, who is a stranger to the contract, there is a contract between A and B, promise or promisee, but C, who is a total stranger, he cannot file a case against A or B. But suppose under a contract, if B has to pay some amount to A, contract amount rupees 10,000 rupees, he has to pay the contract amount of 10,000 rupees, but C is unable to pay, B is unable to pay to A towards the contract amount, then what happens? C may be a common friend of both A and B. So on behalf of B, for the performance of contract, what C does, C pays rupees 10,000 towards contract amount. Now what he has become a, since he is paying consideration of rupees 10,000 rupees for the contract amount, he becomes a stranger to the consideration. So tomorrow if any dispute arises between A and B, then in such case C will be entitled to file a case either against A or B on the contract. Why? Because in a capacity as having paid rupees 10,000 rupees towards the contract amount, he can enforce his right. So this is called, C in that case is called stranger to the consideration. So stranger to the consideration can sue, but stranger to the contract cannot sue. This is the position of law. The other day I said it may move at the desire of the promisee. So it may move at the desire of the promisee means stranger to the consideration may sue is one of the example of that. Okay, if I now you follow all of you. So take down this example. Stranger to contract cannot sue means, stranger to contract cannot sue means the person who is not connected with the contract. Stranger to contract cannot sue means the person who is not connected with the contract cannot enforce his right. He cannot enforce his right or file a case in the contract, or file a case in the contract, or file a case in the contract. For example, if there is a contract between A and B, for example, if there is a contract between A and B, in case of dispute, between themselves, they can file a case against each other. They can file a case against each other. However, C, who is in no way connected with the contract, cannot file a case in the contract since he is a stranger to the contract. Full stop. However, if C has made payment in the contract, even though he is a stranger, however, C, if he has made any payment in the contract, even though he is a stranger, even though he is a stranger, then he is a stranger to the consideration. Then he is a stranger to the consideration. In which case, he can file a case either against A or B. There is a general rule is the stranger to the contract cannot sue. A person who is not connected with the contract cannot sue. But there are certain exceptions in which cases, even though he may be a stranger, he can still file a case. Who are the trustees? Suppose in case what happens in trust matter, when there are several trustees, one of the trustee he has retired or removed. When he filed the case, he signed some document while filing the case. That particular person, trustee, has retired or he has been removed. Then what happens? What happens to the agreement? Suppose one of the trustee has signed the agreement paper. So with the retirement or death of a removal of one trustee, can the other trustees enforce the contract because they are not the party to the contract? Can they do it? Yes, this is one of the case of trustees. One of the trustee, the trustee who has signed the agreement, has signed the contract. If he is not there, the other trustees can enforce the contract on behalf of the trustee. Next one of the joint owner of the property. Owners, when there are several joint owners of the property, suppose you are going to sell your house to the builder for construction of apartments. You are 4 brothers joint owners. 3 brothers are in different places. One person is only one brother is available in Chennai. So on behalf of the other persons, he can enter into a contract. Suppose that brother has gone or is not able to be found, then the rest of the joint owners, they can join together and continue the agreement. So even though they are strangers, still they are considered to be, they have the right to file a case or to sue on the contract against third persons. Then by estoppel means any person who is not party to the contract, but once he has admitted his liability in the contract, then he stopped. Estopped means stopped from denying. He cannot deny the liability. Principle or doctrine of estoppel applies. When one person has admitted any liability, then subsequently he cannot go back on that. He cannot say. Suppose he is not a party to the contract, but he has accepted the liability. He says, I will also perform even though I am not party to the contract. Then because of the, by words or by action or in writing, he has accepted his liability, the principle or the doctrine of estoppel will apply against him, and he also becomes liable, and he can, as a stranger, even though he may be a stranger, he can file a case. Case can be filed against him. Then next one, acknowledgement. Acknowledgement means somebody has acknowledged that he is also a party to the contract. He may not be originally, but subsequently he acknowledges, yes, I am also party to the contract. Then assignment. When some work is assigned to the another person to be done. Suppose myself and himself, both of us are a party to the contract. But suddenly what I do, I say I will nominate somebody else. I will assign my interest in his favor. In my place, he will perform the contract. When I have assigned my right to another person, that assignee can also perform the contract. Even though he is not a party to the contract, he is a stranger to the contract. You follow, all of you? So these are the exceptions to the general rule that a stranger to the contract can also sue. These are the, generally a stranger to the contract cannot sue, but there are certain exceptions as given from section 1 to 5. Under these circumstances, definitely the stranger to the contract can sue. You follow, all of you? Yes.